Hi, my name is Adam Whitmer. I'm the founder and host here at ComplianceCohort.com. This compliance clip is going to talk about comparative evidence of disparate treatment. Now, this is actually the third video in the series that we have been doing on fair lending. And in fact, what we're doing is we're talking about the three types of discrimination that have been recognized by the courts. And this is one of those types. The first type that we've already made a video on is overt evidence of disparate treatment. The second type is what we're doing today, is comparative evidence of disparate treatment. And we released a prior video on evidence of disparate impact. So what these three things are the types of discrimination recognized by the courts, which means when your examiners come into your institution, these are the potential violations you could have. This is how your examiners are going to look at fair lending in your organization. Therefore, it's very important that you understand these types of discrimination, because this is the test that you will have in your financial institutions when your examiners come in and take a look at fair lending. So let's talk about comparative evidence of disparate treatment. Now, this occurs through a file comparison of a protected class and a control group applicant. So essentially what is happening here is your examiners will come in and they'll request files. What they're going to be requesting is a stack of denials and a stack of approvals. That's how this works. Is what they will do is they will take your denials, stack them up, and look for your absolute best denials, the ones that almost made it but got denied, the marginal denials, the ones that didn't quite get through but were turned down. Then what they will do is stack up your approvals, and they will look for your very worst approvals, the ones that barely made it, just barely got through and almost were denied. Then what they're going to do is they're going to look for any overlap on the two, and then they're going to find potential discrimination in that gap in between your worst approvals and your best denials. So that's what comparative evidence of disparate treatment is. Now, your examiners will also be looking for comparative evidence of disparate treatment when it comes to pricing. They'll compare your pricing for your non-protected classes or your control group, maybe mainly your white males. They'll look at pricing and compare that to protected classes like elderly or females or younger individuals or something else, a minority, somebody receiving public assistance. And what they're going to do is be looking for disparate impact through comparative evidence. So those are the two types of ways that we could have comparative evidence of disparate treatment. Now, the challenge with this is comparative evidence of disparate treatment is not necessarily intentional, but the result is discrimination. And what happens is this almost always results from discretion. So smaller institutions, credit unions, community banks who are having in-house loans that maybe have local underwriting and make their own decisions. This is where the risk lies. Larger banks and secondary market loans that don't have discretion don't really have risk of comparative evidence of disparate treatment because they've taken all discretion away. So in community banks and credit unions, this is where some of your biggest risk in fair lending lies, is because you may not have completely defined rules. You give your lender some discretion to make decisions, and this could be a fair lending challenge for you in your organization. And discretion can often come from a couple places: underwriting discretion, and then overrides and exceptions, and making exceptions to the rules when it comes to discretion. Now, as far as oversight for comparative evidence of disparate treatment, oversight can be done by evaluating your discretion and putting some controls in place, like reviewing your denials to make sure that if one person had denied a loan, that somebody else wouldn't have approved it, and there's not another way to make this loan. So that is comparative evidence of disparate treatment. As I said, this is a three-part series that we have released. It's actually part of our Fair Lending Bootcamp that we just released in our store at compliancecohort.com/store. Our Fair Lending Bootcamp is a full day-long virtual seminar where we go through fair lending with slides just like these, and we spend a whole lot of time, 6 full hours, taking a deep dive into the world of fair lending. So if you think that that's something you would benefit from, or somebody in your organization would benefit from, take a look at our store at compliancecohort.com/store and look for our Fair Lending Bootcamp. because it's a deep dive into fair lending. Now, if you're new to the compliance cohort, thank you for joining us today. We have free videos just like this for all of our basic members, and our basic membership is absolutely free, so please feel free to sign up. We have a bunch of training videos just like this. We release about one a week. A few weeks we miss here or there, but it's probably 45 or so videos a year, training videos just like this. You can have access to a bunch of articles and other resources available for free for basic members. So take a look at our site. If you're an existing member, we appreciate you. We thank you for sticking around to the end, because you are the reason we do what we do, even if we trip over our words sometimes. So thank you so much. Until next time, I hope you have a wonderful day. Thanks a lot.